This case highlights two principles of law: more laws, less justice, and bad cases make bad law. Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie, and tomorrow is his 1-year birthday. Are you ready to celebrate? Alright, and this is a breakdown of a lawsuit that I only saw on Twitter because Gad Sad tweeted something out about this lawsuit, and his tweet reads as follows. In response to a tweet from one Yvonne Manley, and under the circumstances, I'm not sure if that handle was intended to be humorous, not using preferred pronouns, a human rights offense, Canadian tribunal rules. To which Gad Sad responded, Dear Progressive at Senate CA members who scoffed and mocked the warnings of two Canadian professors, you owe us an apology. At Jordan B. Peterson. For those of you who may be unfamiliar, this is a debate that has been raging in Canada for at the very least 5 years now. Jordan Peterson and Gad Sad were among the two, saying how these laws, which were adding gender identity as aggravating factors to a number of crimes, would ultimately force compelled speech. The idea of compelled speech is not legal rocket science, but in a nutshell, it's the idea that people are going to be compelled to say certain things, not just prohibited from saying certain things, but that they are going to be compelled to use specific terminology, specifically in this context, pronouns for people who identify as trans. Jordan Peterson and Gad Sad were among the first two to raise the alarm over this, and they were largely mocked, or at the very least disregarded, for raising that flag, and lo and behold, it might seem that their warnings have come to fruition. From Yahoo News, not using preferred pronouns, a human rights offense, Canadian tribunal rules. The British Columbia Human Rights Tribunal ruled in favor of Jessie Nelson, a British Columbia restaurant server who is biologically female but identifies as non-binary. Nelson, who asked colleagues to use, quote, they, end quote, and, quote, them, end quote, pronouns, was repeatedly called, quote, she, end quote, and, quote, her, end quote, by former colleague Brian Gabel, who also called Nelson nicknames such as, quote, sweetheart, end quote, honey, end quote, and, quote, pinky, end quote, the tribunal's ruling said. After Nelson unsuccessfully asked Gabel to stop, the employee went to management, who declined to intervene right away, the court said. Nelson and Gabel then got into a heated discussion about the issue, and Nelson was fired 4 days later for coming on, quote, too strong and too fast, end quote, and being too, quote, militant, end quote. Quote, using correct pronouns communicates that we see and respect a person for who they are, end quote, Devin Cousineau, a member of the tribunal, wrote in the 42-page ruling. Quote, especially for trans, non-binary, and other non-cisgender people, using the correct pronouns validates and affirms they are a person equally deserving of respect and dignity, end quote. And not that I don't trust Yahoo News' reporting, but I don't trust Yahoo News or any other news outlet for that matter. I went to read the 42-page ruling, and yeah, the summary here is sufficiently accurate. I'm not going to go over the nitty-gritty of this decision because there are a lot of unnecessary details in this decision. I am going to go over one fact that was not mentioned in the Yahoo News article, but I just want to read the introductory paragraph and show you what's going on in the following paragraphs, because to some this is going to read like a court ruling, but to others this is going to read like pure judicial activism. Jessie Nelson is a non-binary, gender-fluid, transgender person who uses they, them pronouns. They worked as a server for Buono Osteria, a restaurant run by the respondents Michael Buono and Ryan Kingsbury. The respondent, Brian Gabel, was the bar manager. During their employment, Mr. Gabel persistently referred to Jessie Nelson with she, her pronouns and with gender nicknames like, quote, sweetheart, end quote, honey, end quote, and, quote, pinky, end quote. Jessie Nelson asked Mr. Gabel to stop, and he did not. They asked management to intervene and were told to wait. On their final day of work, Jessie Nelson again tried to speak to Mr. Gabel about this issue, and the discussion grew heated. 4 days later, they were fired. Pressed to explain the termination, Mr. Kingsbury told Jessie Nelson that they had simply come on, quote, too strong, too fast, end quote, and were too, quote, militant, end quote. During that heated discussion that is referenced here, the court actually comes to the conclusion that Jessie Nelson put their hands on Mr. Gabel, but it was not determined to have hurt Mr. Gabel, so it was not assault, although that is not necessarily the legal definition of assault, but they do come to the conclusion that in this heated argument, it actually got physical. But before we get there, I think a lot of people who have not read the decision in order to understand the decision and potentially the decision maker might find it relevant that the decision maker, the administrative judge in this case, actually uses the first introductory paragraphs to gender everybody in this case. Section 3, Facts. In this section, I set out my findings of fact. These findings are based on the testimony of Jessie Nelson and the following witnesses. Stacey Copeland, she, hers. Katie Grill Donovan, she, hers. Michael Buono, he, his. Nova Melanson, she, hers. Brian Gabel, he, his. The reason why I say that this is probably going to reek of judicial activism to a great many people reading this is that I suspect, but I do not know, I just strongly suspect that these parties to the lawsuit did not specifically ask to be gender identified in the judgment. The other explanation is that this is a case dealing with gender pronouns, so it only makes sense that the administrative tribunal judge specifies which pronouns they're going to use for which parties, but the judge throughout this lawsuit refers to Jessie Nelson as the they that Jessie Nelson asked to be referred to as. And just on the facts of the lawsuit, Jessie Nelson was subject to a 3-month probationary period. The termination occurred after 4 weeks. The complaint was filed, and according to this judgment, the restaurant and its principals now have to pay tens of thousands of dollars in damages. Mr. Kingsbury interviewed and hired Jessie Nelson as a server for the restaurant. Their first shift was May 27, 2019. The first 3 months of their employment was a probationary period. When they started, Jessie Nelson talked to Mr. Kingsbury about how important it was to them to be properly gendered in the workplace. At that point, Jessie Nelson had come out as trans relatively recently. They explained that it is a daily struggle to have their pronouns properly recognized. Getting back to my introductory statement about how bad cases make bad law, this case seems to have less to do with gender identity per se and more just to do with workplace harassment and bullying. Alright, and just to skip ahead on the facts for a bit, Jessie gets misgendered by an employee at the restaurant, an employee uses improper nicknames, and the situation escalates. It is brought to management, and apparently management does nothing, and there's one final heated exchange that leads to the termination during the probationary period. At least 3 times during their conversation, Mr. Gobel called Jessie Nelson sweetie, sweetheart, or honey. Each time they told him not to. They told him, as they had before, quote, "My name is not Pinky or Sweetie. If you can't use my pronouns, at least use my name," end quote. Mr. Gobel said that he was not going to change who he was. The people who came to his bar are, quote, "ladies and gentlemen," end quote, "boys and girls," end quote. If anyone wants to be called differently, they can tell him and he will respect that. Jessie Nelson tried to explain that this would be a hard conversation for a guest, and it is kinder not to assume a person's gender and require them to have this conversation when all they really want to do is eat their food. By the 3rd time they had to ask Mr. Gobel to use their name, Jessie Nelson was frustrated. They spoke sternly and with a raised voice, quote, "Brian, that is not my name is Jessie. Call me by my name," end quote. It's something I have said time and time again in previous vlogs. One of the most frustrating aspects of the practice of law is that when it comes to a decision, nothing else matters except for what the judge thinks, and clearly in this case, the judge on every issue of contradicted evidence sided with Jessie Nelson. Even when it comes to the final confrontation that led to the termination, where it was alleged that Jessie Nelson put their hands on one of the defendants, the judge comes to the side of Jessie Nelson. I accept that Jessie Nelson used some force on Mr. Gobel's back. In their own words, they were experiencing a rush of adrenaline and, quote, "emotional chaos," end quote. They were upset and angry. Along with their words, they intended to find some way to hurt Mr. Gobel as he had hurt them. The contact was enough to shock Mr. Buono and Ms. Melanson. However, I do not accept that it is fair to characterize this as a violent physical assault. It did not hurt Mr. Gobel, and he does not claim it did. Rather, he was surprised by it, and the touch was unwelcome. It was a parting slap on the back. Appreciate here how the judge is minimizing this incident in order to write it off as a non-legitimate reason for having terminated Jessie Nelson, what the judge himself describes as something that was shocking to 2 of the witnesses. It was just a parting slap on the back, and it could not justify the termination of Jessie Nelson. And at this point in time, it might be useful to see the actual provision of law in virtue of which Jessie Nelson's complaint was filed. Discrimination in Employment, Section 13. 1. A person must not A. refuse to employ or refuse to continue to employ a person, or B. discriminate against a person regarding employment or any term or condition of employment because of the race, color, ancestry, place of origin, political belief, religion, marital status, family status, physical or mental disability, sex, sexual orientation, gender identity or expression, or age of that person, or because that person has been convicted of a criminal or summary conviction offense that is unrelated to the employment or to the intended employment of that person. Whereas the defendants had raised that the termination was justified in virtue of the escalation of that final incident, the administrative tribunal judge comes to the conclusion that there was nothing sufficiently serious about that escalated incident to warrant termination, and that the termination was made in violation of Section 13 of the British Columbia Human Rights Code. And as relates to gender identity pronouns in the context of human rights law, this is what the administrative tribunal judge writes at paragraphs 83 and 84. I appreciate, as the respondents point out, that for many people the concept of gender-neutral pronouns is a new one. They are working to undo the, quote, habits of a lifetime, end quote, and, despite best intentions, will make mistakes. Unfortunately, this learning is done at the expense of trans and non-binary people who continue to endure the harm of being misgendered. Human rights law is concerned not with intentions but with impacts. This does not mean, however, that intention is irrelevant. A person's intention can go a long way towards mitigating or exacerbating the harm caused by misgendering. Where a person is genuinely trying their best and acknowledges and corrects their mistakes, the harm will be reduced. This is evidenced by Jessie Nelson's response to mistakes made by Mr. Kingsbury, who proactively took steps to correct himself and make the workplace more inclusive. These mistakes, though they may have been painful, did not lead them to file a human rights complaint. As they explained in this hearing, quote, "I don't expect perfection around my pronouns. I never have," end quote. This was the case with Mr. Compelled. And when it comes to the termination and the motivating factors for the termination as relates to a violation of Section 13, this is what the Administrative Tribunal judge writes. To prove that the termination of their employment violated the code, Jessie Nelson must show that their gender identity and expression was one factor in that decision. It does not need to be the only or overriding factor. Mr. Bruno says that there were two reasons underlying his decision to terminate Jessie Nelson's employment. Their decision to talk directly to Mr. Compelled on the evening of June 23, which he considered insubordination, and their conduct in insulting Mr. Compelled and hitting him on the back. Though I have found that Jessie Nelson was not in fact insubordinate, I will accept for the purposes of this analysis that Mr. Buono thought they were. The respondents argue that these two reasons constitute a complete and non-discriminatory explanation for the termination. I do not agree. And when the judge does not agree, all the judge has to say is, "I do not agree," which is exactly what this judge does here. In this case, I have no difficulty concluding Jessie Nelson's gender identity was a factor, if not the factor, in their termination. This conclusion is supported by both the explanation offered by Mr. Buono as well as what Mr. Kingsbury told Jessie Nelson in their final call. Accepting Mr. Buono's explanation for their termination, it is apparent that Jessie Nelson was terminated in connection with their efforts to address discrimination. There is no dispute that their conflict with Mr. Compelled was based in part on his ongoing use of female pronouns and nicknames, and that Jessie Nelson objected to that conduct because it harmed them in connection with their gender identity. The judge came to the determinations that the judge came to and issues the following order. Conclusion: I have found that Buono Osteria, Mr. Buono, Mr. Kingsbury, and Mr. Compelled discriminated against Jessie Nelson in their employment on the basis of their gender identity and expression in violation of Section 13 of the Code. I make the following orders. A. I declare that the respondents' conduct contravened Section 13 of the Code. B. I order the respondents to cease the contraventions and refrain from committing the same or similar contraventions. C. I order Buono Osteria and Mr. Compelled to pay Jessie Nelson $10,000 as compensation for injury to their dignity, feelings, and self-respect. D. I order Buono Osteria, Mr. Kingsbury, and Mr. Buono to pay Jessie Nelson $20,000 as compensation for injury to their dignity, feelings, and self-respect. E. Within 3 months of this decision, I order Buono Osteria to 1. Add a statement to its employees' policies that affirm every employee's right to be addressed with their own personal pronouns. 2. Implement mandatory training of no less than 2 hours for all staff and managers about human rights in the workplace. F. I order the respondents to pay Jessie Nelson post-judgment interest on the damage award until paid in full based on the rates set out in the Court Order Interest Act. So that is the decision, and at this point in time, it's going to get increasingly difficult to contradict or deny the warnings that Jordan Peterson and Gad Saad issued to the Canadian Senate. At its core, this lawsuit seems to be more akin to bullying or potential workplace harassment. You know, the same way that if I worked at a restaurant and people kept calling me shorty, I might not like it and I might file a complaint and it might be very problematic, but there were already laws on the books to deal with that. And then you end up with judgments like this, which are going to make a lot of people very angry, very weary, and are actually going to exacerbate the very same problems they purport to want to resolve. So that is the judgment. Let me know what you think about the judgment in the comment section. Let me know your thoughts. And if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm.
Tina, you fat lard, come get some dinner.
If you want to support the channel, all of these support links are in the pinned comment. Robert Barnes and I do weekly streams every Sunday. We do weekly streams with a guest every Wednesday called The Sidebar. If you want to find us and support us on Locals, where supporters get lots of exclusive content, you can find us at
VivaBarnesLaw.locals.com.
All of my content is also on Rumble if you want to catch it there, but more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out.